Hello and welcome to the New Indian Express. The sudden death of billionaire businessman Sunjay Kapur has triggered a family feud over his inheritance worth rupees 30,000 crore. The feud primarily involved Sanjay's wife at the time of his death, Priya Sachdev Kapur, and his ex-wife Karisma Kapoor. A will has been presented by Priya, reportedly leaving Sanjay's entire personal estate to herself. Karisma's children allege that Priya had forged the will and they moved to the Delhi High Court. They have also raised the claim for one-fifth of their father's estate. Priya's lawyers argue that they have already made a payout of rupees 1,900 crore to the kids. Here we are examining the legal issues surrounding the inheritance case. To discuss this, I am joined by Supreme Court lawyer Advocate Nipun Saxena. Hello Nipun, welcome to the New Indian Express.
Hi, Alan. Thanks. Always a pleasure coming here.
Now, the Sanjay Kapoor inheritance feud has blown up. Aside from the celebrity angle, how is this case important legally with respect to succession rights?
Well, you see, one of the reasons why this case is slightly curious is that uh, a claim is made for partition in the estates which are self-owned properties of Sanjay Kapoor, right? And they are the claimants or the plaintiffs before the court are the children from the first wife, right? And the claim is being made against they are making a claim in respect of partition of the entire property, which is the estate of their father, right? The wife, of course, is contesting, which is the second wife now is contesting that uh, under some will of March of 2025, all his estates stood transferred in her name. And therefore, the children are not entitled to anything, right? And the children, in their independent right, are claiming that we have a one-fifth share in our father's estate by virtue of being what they call class one legal heir, right? We'll explain that later if you have any questions on what this class one is, so on and so forth. So essentially, one side is arguing for the property or the estate to be partitioned and their share, which is one-fifth, must go to them, whereas the other side, which is the wife, the second wife, saying that under a will, all the property goes to her.
Okay, now if I'm not wrong, the succession, all of it happens under the Hindu Succession Act. And under the Hindu Succession Act, there is classes of heirs. So could you explain the classes of heirs with respect to this case?
Well, the classes of heir, there are essentially two classes of heirs that are recognized under the Hindu succession. Now, the first class of heir is, first of all, let's understand succession in its very basic form. There are two forms of succession. One is testamentary succession, which is succession through a will. If it's a succession through a will, then you need not even be relatives. A will can be made in favor of a complete stranger also, right? So long as the will, of course, is not disputed, it is not suspicious, so on and so forth. However, if a person dies without making any will, then Section 8 of the Hindu Succession Act kicks in, which deals with intestate succession. Intestate succession essentially means that when the person has died without making any will. In that case, you have two separate categories or classes of heirs which are recognized under the Hindu law. First are called class 1 heirs and second is class 2 heirs, right? Now, class 1 heirs would essentially be widow, mother, sons, daughters, right? And specified descendants of predeceased children. And class 2 heirs kicks in only when there is nobody in class 1, right? So then it could go to deceased father, it may go to siblings, other relatives which are provided in the schedule, right? So the schedule mentions all those categories. Now the children are essentially claiming that since they are children born from the father, therefore they are class 1 heirs, right? And therefore they are entitled to the estate in the share which is theirs. They are each claiming one-fifth share. Whereas the wife, the second wife, is claiming that Section 8, of course, this is going to be the argument before the court, that Section 8 is inapplicable because it's not a case of intestate succession. It's a case of testamentary succession or succession through a will. Right? If it's a succession through will, then the husband could have transferred the entire property to whoever he wanted to transfer. Of course, when such a will is produced, the other, which is the plaintiffs who have filed the suit for partition, can always take leave to amend their plaint and say, now we also want to challenge the will because it is based on a suspicious circumstances, or that the will itself is fabricated or forged, right? So then all sorts of things, handwriting matches, expert opinions, etc., will all be taken into consideration.
Okay, now with respect to Sanjay Kapoor's company, which is the Sona Group, it's a family business. It was actually founded by his father. Now, all we hear about is the Priya Sachdeva versus the Karisma Kapoor children. The legal feud is what we are hearing about. What about his mother and sister? Being a family business, don't you think that they have much more of a say in the matter?
One has to find out whether they actually had any control in the company, right? Because one has to also understand the organizational setup of the company. Third, whether it is the company's property which is subject matter of this suit, or whether it is the personal estate. Because Section 8 of the Hindu Succession Act only deals with the personal estate of a person. Right? A company's property, company is a separate, distinct juristic entity. Right? And if there was a dispute, let's say between Sanjay Kapoor and his sister or his mother, then I'm sure they would have already initiated that while he was alive. Right? If they wanted some claim in the shares of the property or any of the properties owned by the companies, etc., etc., right? But insofar as his personal assets are concerned, which is to say his personal properties are concerned, this will be outside the realm of this dispute. Unless they come and say that no, this will is false. Uh, Even if they are able to establish that this will is false, then the mother of Sanjay Kapoor may be entitled to claim something, right? But definitely not sister.
Okay, now as you said, there are a lot of claims that have come up. There were a lot of arguments with respect to the veracity of the will. They claim that it has been forged. There was a lot of mysterious circumstances surrounding the will. So, could you explain like what were those mysterious circumstances with respect? What are they arguing about with respect to this case?
Well, from whatever has been argued before the court, one can only at this point of time make a guesswork, because of course the plaint of it or the documents are not in public domain as yet, right? But essentially what one gathers from news channels, as well as from what Live Law and Bar and Bench, etc., other news portals, legal news portals are reporting, is that there is a will, and that will mysteriously appears. Uh, it is hastily read, and on that basis, certain estates stand transferred, and that essentially is the basis of claim. Of course, right now in the last order, as has been passed by the Delhi High Court, they have not yet put their written statement. So one does not know what their strategy is going to be. But it appears that if there is in fact such a will, that will be pressed into service to dispute the claim and to completely negate Section 8 of the Hindu Succession Act. Because if it is proved that the will is genuine, and the signatures, etc., whatever, and if it otherwise meets the requirement, namely that it was seen, witnessed by two witnesses, and then also questions whether it was registered, unregistered, so on and so forth. There's a entire jurisprudence behind wills, right? If it is established, then naturally Section 8, through which the children are claiming property, will have no
So
applicability
here,
whatsoever.
Section 8 basically means partition. Partition is what Section 8
On the
in the
basis of
basic claim.
interstate succession. Interstate succession is when a person has not written a will and has passed away, right? So if there is a will, then Section 8 has no application, and therefore the children have no claim to partition. Also, the question is that whether the will transfers any assets to the children, or whether the will completely uh, uh, decides to de-recognize children. There are also those instances where somebody is disinherited in the will itself, because it is called, for a reason, it's called the last will and testament of the testator. The will, if it is found to be proven, the courts have held that they must respect the last will of the testator.
Now, talking about the children, I think there was an argument that 1,900 crore, an amount of the asset amount, has been given to the children. What do you have to say about that? What is that claim all about? Because is it substantial? Is it, do you think, how was that transfer made? Anything? Do you have an opinion on it?
Well, if the argument stems from the fact that it is made under a different trust, then then of course that reference must come in the will. If there is any such trust, that the reason why I'm not giving any amount to the children is because they are already beneficiaries under a trust which is separately created. But if there is no reference of that sort, then merely because they are beneficiaries under a different trust does not disentitle them from claiming anything under Section 8. Right? In fact, one can go, the principle of law which governs will is to the extent which says that even in cases, let's say a will has missed out certain properties, and there is no statement in the will which says all future properties or anything that I have acquired. If it has given a schedule of a property and certain properties are left out, then in respect of those properties which are left out, the children can still file a suit and claim it to have passed on through interstate succession, right? So one has to really look at the will. What is that will that says? Whether A, it confers any right, title, interest, or claim on the children. B, to what extent it gives in. 3, has the will specifically excluded the children? 4, if the children are specifically excluded, then has the will made any specific recital as to the reason why they are excluded? Right? And whether the will makes reference to this 1900 crore which has now been transferred by way of a trust. All those things have to be seen. This is, of course, in addition to the fact that the will itself is found to be proved,
Yes.
which is to say that it conforms with the requirement of the Succession Act, it conforms to the requirement as laid down under the Indian Evidence Act.
Yes. Now, the most recent order in this case by the Delhi High Court was that a list of all the immovable and the movable assets under Mr. Sanjay Kapur's, the late Mr. Sanjay Kapur's estate, has been made available. So, do you think that there has been other arguments saying that this 30,000 crore, which is what everyone assumes is Mr. Sanjay Kapur's total worth at the time of his death, is supposedly blown up? Do you think that might be the reasoning behind Delhi court's uh, judgment demanding the list of all the properties or all the
You
assets?
see, I feel there's a different reason. It's not about what is being blown up out of proportion or anything of that sort. There is an application, as one can see from the order. That application is to restrain the defendant, which is the wife, the second wife, from alienating or creating third party rights in any of his estate. Now, if you have to pass that order, then you must know what are those properties in which third party rights, etc., can be created, which is why an order and a direction has been passed by the Honorable
Now,
Delhi
what
High
is this third party rights you were talking about?
Third party rights could be anything. I can sell off that property to XYZ. I can mortgage it with a bank. Those are third party rights, right?
Yeah.
So that no third party rights are created in these properties. Therefore, a direction has been passed by the Honorable Delhi High Court calling upon the defendant to furnish on its affidavit as to what is the extent of the properties which form part of late Mr. Sanjay Kapur's personal estate, right? Now, once a direction has been passed, the defendant is supposed to abide by that direction and give full and complete disclosure of all the properties which form part of his estate. Now, that could be mentioned in the will, that could be properties which are not part of the will, that could be anything, right? So one now, and that would also respond to your question whether it is conflated out of proportion or it is not conflated out of proportion, right?
Okay, now a personal question. Have you seen a lot of cases like this where the normally I think proceedings like this tend out to be very ugly, but have you seen a lot of proceedings where there's a partition claim and the will has been called for forged? Have you
Yes, it's a standard practice in civil suits which are based on interstate succession. One party
Yeah.
will always claim partition in the estate. The other party would always set up their defenses. Those defenses could be existence of a will. It could be these class one legal heirs being disinherited from the property, some relinquishment deeds, so on and so forth. So it's in that sense, it's very normal what we see in courts.
Yeah. So coming to my question was like, see, for instance, what does a normal person do? Because I've read that if you create a trust while you're living, or you gift it to the people who you want to give it, it apparently takes away all this legal fighting that happens between the heirs. That can be alleviated. So, is it true? Do you feel that it's true that if you create a trust or a gift, this drama could actually.
Well, you see, what happens is there are different instruments through which you can transfer property during your lifetime and after your lifetime. You usually gift properties. If you are gifting them, then that's the end of the question. If you are implementing something called a family settlement while you are alive, right, in terms whereof you have taken everybody's signatures, right, and said X will go to this person, Y will go to this person, and you do it during your lifetime, that's also a preferred mode of asset distribution. Third way is, of course, a will, uh, right, and fourth is, of course, is to create a trust and then nominate beneficiaries of that trust. The trust will function through trustees. So these are all different ways, but Alan, at the heart of all of these things is the intent. People who have the right intent will never raise a dispute. Wherever there is a problem with one's intent, either because both things cannot coexist together. You cannot have a situation where there's a will and also there is a partition suit, right? One would necessarily eliminate the other, right? So somebody here is not stating things accurately. So it all ultimately boils down to the intent of a person.
Thank you for explaining it in the most simplest of ways. Thank you.
Thank you so much, Alan. Thank you for having me.